Now that we know the structure of the federal court system, and we know that the higher courts can review the decisions of the lower courts, let's take a closer look at what the individual court levels do. And to do that, let's just focus on one court for each level. So from our federal court system diagram, I've just highlighted the District Court of the Northern District of California and the United States Court of Appeals for the Ninth Circuit, the Ninth Circuit Court, and the United States Supreme Court. Now, when two parties have a legal dispute in the federal court system, they start at the very bottom of the court structure, in the district court. And we say that the district court has original jurisdiction. Original jurisdiction. And jurisdiction just means the power or the ability to hear and resolve a dispute. We sometimes abbreviate jurisdiction with a JX. And we say that the district court has original jurisdiction because it's the court that has the power to hear the dispute in the very beginning, at the origin of the case. Usually it's when one party files a lawsuit claiming that some other party has done something wrong. And now the original jurisdiction court, the court of original jurisdiction, is sometimes also referred to as the trial court. The trial court. And that's just because this is the court where trial happens. A trial court is what we usually see on TV. It's the court that most people typically think of when they think of court, with juries, witnesses, attorneys making objections, and things like that. Now, there are a couple of things that happen in the trial court. The trial court does two main things. The first thing that the trial court does is it answers questions of law. Questions of law. So for example, let's say that there is a murder case, and the alleged murder happened in a national park, which is federal land. So we're in federal court. Now the question is, can a man be guilty of murder if he shoots a gun at another person and he doesn't hit that person, but that person is so frightened by the gunshot that he has a heart attack and dies? Well, let's sketch that out here. So we've got one person standing here. He's holding a gun. And there's another person here. They're in a national park. And the first person fires a gun at the other person, but he misses. But this person is so frightened by the gunshot that he has a heart attack and he actually dies. Well, under these circumstances, is this murder? Is this murder? Well, that's a question of law. It's a question for the court to decide, and it's a question of the proper rule of law. The court will answer that question based on its understanding of the correct law that should apply to that situation. And questions of law are decided by the judge. The judge in the trial court answers questions of law. That's the judge's job. Okay? Now, if both parties agree on what actually happened, and the parties here in this example would be the prosecution and the defendant. Well, if the parties agree on what happened, so they agree that the defendant did shoot a gun at the other person, and he didn't hit the other person, but the other person died of a heart attack that was caused by the fright of the gunshot. Well, if the parties agree that that's what happened, then the only thing that the parties would argue about is whether under those circumstances the defendant is actually guilty of murder. And presumably the defendant would argue that no, that's not murder. I didn't shoot the person. And the prosecution might argue that, well, you might not have hit him, but you shot at him and you caused his heart attack that killed him, so that is murder. Well, in any event, the judge answers questions of law, and so each party would argue what it thinks should be the correct law to the judge, and then the judge would decide. But let's say that the parties don't agree on what actually happened. Maybe the defendant denies that he shot a gun at the other person. Or maybe he admits that he shot at the other person, but it's unclear whether the gunshot actually caused the heart attack. Maybe the man was already having a heart attack, but it was only after the gunshot cleared the crowd that anybody noticed. Well, in that case, the trial court needs to do the second thing that trial courts do, and that is answer questions of fact. Questions of fact. That's the other thing that trial courts need to do. Okay? So did the defendant actually shoot a gun at the person who died? And did the gunshot actually cause the heart attack that killed the person? Well, usually a jury decides questions of fact. That's the jury's job in the trial court. And it decides questions of fact like this after seeing the evidence. So hearing testimony of witnesses, maybe some medical experts who give their opinion on when the heart attack actually happened. Or maybe there's some evidence about whether the bullet actually came from the defendant's gun. Okay, so based on evidence like that, the jury would decide what actually happened. Or we say that the jury is the fact finder, the finder of fact. Now that's what happens in a trial. There are some trials that don't have a jury. We call those bench trials. In a bench trial, there is no jury. The judge does the job of both the judge and the jury. So the judge answers questions of law and it answers the questions of fact. Okay, so sometimes questions of fact are actually answered by the judge too. And that's in a bench trial. So in a bench trial, the judge is the finder of fact. But in a regular jury trial, the judge only answers the questions of law and the jury is the finder of fact. All right, notice that in the trial court, both the questions of law and the questions of fact have to be answered. Even if we know that someone can be guilty of murder for shooting a gun at another person and scaring that person to having a heart attack, even if we know that that is murder, we can't find the person in our example to be guilty of murder if we don't know whether that's actually what happened. Okay, so answering the question of law that yes, this could be murder isn't enough. We have to know what actually happened too. We have to answer the questions of fact. Did that actually happen? On the other hand, just knowing the facts and not knowing the law isn't enough either. So let's say we know that the person in our example did shoot a gun at the other person, and we might know that the person did die of a heart attack and that the heart attack was caused by the fright of the gunshot. But we need to know whether the law would even consider that to be murder before we can say that this person has committed murder. So we need both. We need to answer both the questions of law and the questions of fact. And that's what the trial court does. And in the federal court system, the trial court is the district court.